Welcome to another episode of Work Comp Talk. We are super excited that you have joined us once more. If you're new to the podcast, make sure you hit that subscribe button on whatever pod platform you're listening to us. That way you get the notification that if we have new episodes, you get first dibs on and you get to listen to it. As well as YouTube, for those of you that like watching us on YouTube, make sure you hit that subscribe button and also the little bell notification. That way you can get notified when we dump some new content within our YouTube channel. Today's episode is going to be a bit different and quite frankly, a lot different. We have been bombarded with tons of comments, which we love. There is a lot of engagement happening. And I think the beauty of being able to have this podcast that makes it very different from other podcasts out there is we actually take the time to engage and answer most of the questions that are dumped on all of our social media. We have Bilal Kassem essentially being one of the best workers' comp attorneys in Northern California is part of the podcast. And what best than to get the knowledge from someone who's been litigating for years? You know, this is not coming from, a case manager, an assistant case manager. It's coming from someone who's been in the field for super long, and you get to ask those questions directly. So, because you do sit here and answer most of these questions, what best than to actually create a video of questions that are being asked within the content we have already shared? It might be a question that you might have thought about or you probably didn't even think about, but you might be interested in the answer. So, Bilal, thank you for joining us. This is going to be different.
It's a pleasure to be here. No, like you said, it's very difficult for us, I think, to answer questions in a lot of detail that, I think people really want to know about.
Yeah.
My fingers get tired from typing. We get a lot of great questions, and there's a lot of questions that need long answers, and it's not always easy to just say yes or no or do this or do that. So, I think it's great that we've gotten a lot of feedback from our audience and listeners with some great questions, and I'm happy to be able to share some of my answers here live today. I think it's a great opportunity to talk, and quite frankly, I've been an attorney for a long time, and I have both worked as a defense attorney in a prior life, as well as now representing injured workers. So I think that I have a fairly educated perspective from both sides on a lot of issues that come up in workers' comp. So I love to be able to share that knowledge with people. So I'm happy to be here.
Definitely. So there is, again, a lot of questions we're going to be diving into. By the way, make sure that if you're listening to this podcast, you automatically realize and assume that every case is different. And the most important part is this does not create a client and attorney relationship. These are just questions we're answering on social media. And of course, if you ever need any more assistance, you can always reach out. We're going to leave some links down below where you guys can click. And if you feel you want more information, go ahead and schedule a free consultation. Consultations are meant for you to ask questions and get answers. And then depending on how you feel about your situation after the fact, then you can schedule yourself to get an attorney or not. But the consultation's free. You don't lose anything besides a few minutes of your time. So let's dive into it.
Sure.
Which one do you want to go into first?
So I got a great question here about spine surgeries, including specifically spine surgeries and related settlements. So I think that's a good place to start.
Perfect.
So I think how spine surgeries come up in settlements can really be two different ways. So for example, with a lumbar fusion, those are expensive. And so dependent upon the type of settlement that you want to go with, that can obviously impact the value. And so there's something called official medical fee schedule in California, which ultimately determines the amount of money that an insurance company is liable for medical treatment. So for example, you'd go to, Dr. Bob's surgery center for your spinal fusion. And Dr. Bob may be a world-renowned surgeon, and he's going to charge you accordingly. So, Dr. Bob could say, look, I'm going to charge you $100,000 for a lumbar fusion. Mm-hmm. Dr. Bob's not going to get paid $100,000 under official medical fee schedule, which is legally all the insurance company's liable for. And so to the extent we're talking about something like a lumbar fusion and how it impacts settlement valuation, there's two different numbers. There's the number that what it may cost you out in general real life with or without insurance, and then there's the number that the insurance company is actually liable for under California workers' comp law.
Wow.
And so people have to take that into account, because if you say, hey, I want $100,000 towards my settlement to account for lumbar fusion, the insurance company may only be liable for like $25,000 of it under official medical fee schedule. And so you have to be cognizant of what their liability is in assessing whether or not the amount that they're offering you to buy that out is adequate.
That's insane.
Yeah. On top of that, though, generally speaking, the more surgery, the more medication, treatment, whatever it is you need in your case, the more the insurance company is willing to pay to make it go away. And the more they're willing to increase the value of what they're offering to buy out your future medical care, because they perceive that there's this financial liability that's going to be there if they don't. And so official medical fee schedule isn't a limit. It's not the max you can get for your future medical care, but it's just a guideline, you know?
Right.
It's like, you know, if you could buy a Honda Accord from a dealership down the street for 20 grand and then the dealer down the street's charging 40 grand, why are you going to go buy it from the 40 grand dealer? You know, it's
right.
the same thing when they're buying out your medical. They're like, well, if it's not going to cost us that much, why would we give you more? You know?
Right.
And so there is a cost benefit analysis in that regard too. Something for spine surgeries in particular that's a real consideration is, what if your spine surgery goes wrong? What if you get paralyzed?
What if?
If you want a good podcast, listen to Dr. Death, right? That's a spine surgeon who went around butchering people, and he caused some paralysis in some patients. But, you know, there's this scare that maybe surgery's not going to go your way. And spine surgery, generally, if you talk to a spine surgeon, they'll tell you it's risky business. You know, I think there's some surgeons that are incredible surgeons. They're very talented and they'll do a great job. And there's others that maybe they're not so confident in, even if they are a good surgeon, that you'll get a good result, even if they were at their best that day, you know, depending on what's going on with you and what kind of issues you have. And so when you're talking about spine surgery and you're thinking about settlement, you also want to consider whether settling out your medical is the best decision, especially if it's within 5 years from your date of injury. Because if you're within 5 years from your date of injury and something goes wrong with surgery, you can actually reopen your case to collect new and further permanent disability.
Good to know.
So if you let's say you settle your case out by compromise and release, which is a lump sum settlement, and they buy out your right to a lumbar fusion, and you have, you know, you get $100,000 all told, right? That's it. And let's say you're paralyzed from your waist down as a result of a botched surgery. You can't go back and reopen the case.
Damn.
And as long as there's no malpractice, you can't sue the doctor or the medical facility. So then, cool, you got $100,000, and now you're paralyzed from the waist down.
It's not a case or a scenario that somebody actually even wants to be in.
No, but you didn't know. Maybe your doctor was like, hey, look, you know what? I can do this surgery for you. You maybe don't need it right now, but come back in a year. I'll do it. You know, we'll chop you up. It'll work out well. You'll be great, 100%. But that doesn't happen.
Yeah.
Right? That's not all the cases. And we've had cases where people had failed lumbar fusions where they end up with what's called a spinal cord stimulator. People have extreme drug dependency for pain medications and stuff after things like that, and it can be crippling, like in every sense, mentally, emotionally, physically. But I think the thing to consider is whether or not you want to close out your right to reopen and close out your medical care when there's the possibility that maybe as a result of a botched surgery, your case is worth $5 million, right?
Right.
So you have to take that into consideration too, if that's like...
So in that case, I know we were talking about the CNR settling, giving a lump sum payment, you get the whole payment, and then you're done. You might want to consider a stip settlement.
Yeah, so for those that aren't aware, stipulated award is it's a different type of settlement where they don't buy out your medical. Typically, you receive the value of your permanent disability paid over time. And then you keep an ongoing right to open medical care, which means that you can ultimately continue to seek care through workers' comp insurance indefinitely. And typically when you stip your case too, you also reserve that right to reopen your case for new and further disability if your condition deteriorates within 5 years from your date of injury. And deteriorates could be due to botched surgery, natural progression of a disease or illness, whatever it is. So your condition can get worse, and especially after a risky surgery.
Interesting.
Yeah.
That's good to know. And again, we have a podcast all about settlements, the CNRs, and as well as the STIPs. You can also dive into that. We will be linking that below in our description, or you can find the video somewhere within this video if you're watching it on YouTube. So what's our next question? And we do want to thank Derek66. Is that an L? Derek66L
yes.
on YouTube, who literally dumped so many questions within YouTube. We do answer them, as well as TikTok. That's another form where we have been getting a ton.
Yeah, Derek, thank you. We really appreciate the questions. Keep them coming. I'm happy to talk about it. Another question I got was regarding late payments. So in particular, they wanted to know whether there's any kind of penalties for late payments after a stipulated award. And so Normally, if you have a settlement, I assume this is regarding a stipulation and award, where someone received biweekly payments of permanent disability, open medical care, the board still retains jurisdiction over the case despite the case, quote unquote, being resolved. And really, it's to monitor the treatment award and make sure that benefits are being paid and stuff like that. So once you settle your case, you can still technically go back to the Work Comp Appeals Board. You'd need to file a declaration of readiness to proceed. If there's late payment on the settlement itself, the permanent disability, you can actually file a penalty petition, and you would allege that there's these two labor code sections, 5814.5, 5814, and actually a third, 5813, which would give the court jurisdiction to award penalties in the event of a late payment. And so settlement payments and stipulated awards are a little bit different than compromise and release settlements. Typically, they're both, paid within 30 days, but paid within 30 days can mean a different thing if your payments are ongoing. It means they start within 30 days.
Right.
But really, when you have a stipulated award, if there is permanent disability that's due and accrued, meaning that it wasn't advanced while the case was still pending or wasn't fully advanced because the case was resolved early enough, whatever the case may be, there may be some permanent disability that should have been advanced, but there was a legal reason not to, and now the case settles. All of that permanent disability that is accrued and payable is all due immediately once you've settled the case.
Interesting.
Yeah. So when you see settle a payment within 30 days on a stip, when there's retroactive permanent disability due, that means that the insurance company needs to pay all of that immediately within that 30 days, and then they continue with the ongoing payments, right?
Interesting.
So a lot of people don't think about that. The insurance companies love to just be like, okay, well, we started advancing, we'll keep advancing, but we're not going to go back and pay you for that year that already accrued and should have been paid lump sum. And so that's a common reason why we have to seek penalties and sanctions on stip awards in a lot of cases.
And this is something someone obviously wouldn't even realize that they can get, if they didn't have an attorney. Because it's, again, you said the insurance company can play dumb.
Yep.
And can be like, oh, okay, well, let's do this moving forward and let's just forget about the past. That could be a lot of money that you leave on the table.
Yeah, sometimes the permanent disability that's accrued is like $20,000, $30,000, $40,000. It can be a lot of money all due up front. And the insurance company will just start issuing checks. And I literally just had this happen on a case where the case had been going on for several years. Mm-hmm. My client was only advanced a small portion of permanent disability, then they stopped until like a year and a half went by. And so we finally settled the case by stipulated award, and the insurance company just started issuing the payments at, $290 a week, the $580 every other week, like normal. And so I bugged the defense attorney. I'm like, hey, look, like, you guys stopped payments like a year and a half ago and like didn't pay anything, and now you just started paying payments again. Like, what gives? And they're like, oh, well, we thought it blah, 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 whatever it is. But then they look into it, and as it turns out, it's owed. And then they issue my client the check, and it turned out to be a lot. It was like $7,000.
Hey, when you're out of work, when you're injured, $7,000 is a lot. Just think about it.
Dude, it's a lot for anyone. I'd love $7,000 extra in my pocket right now, that especially with the cost of gas and whatnot.
Tell me about it.
Yeah.
Okay, cool. So, what else do you have in there?
So I got another question about settlements with multiple body parts involved. So, if someone has a back, a leg, a foot, and everything's injured, you have multiple issues going on, like how does that, I assume, impact the settlement, and how do you account for those things? And so one, with a compromise and release, you want to make sure that you're valuing the permanent disability for all your body parts that are involved, right? You want to make sure that you have ratings for all your body parts. If you don't like the ratings you got from the doctor, make sure you go to QME. Make sure you get the right QME, not the wrong QME. But ultimately, you want to make sure that those are accounted for in the value of the settlement, because permanent disability is set by statute in California. There's a monetary value associated with it. So the insurance companies love to just lump things together and say, oh, well, we'll give you 50 grand or 20 grand, whatever it is. But really, you want to make sure that that 20 or 50 grand is based on the value of the permanent disability that you would be entitled to based on the rating you have. On top of that, you want to make sure that you're getting a fair amount of money towards the medical for each body part, that you're really kind of figuring out, like, hey, are they just giving me some lump sum that only accounts for the surgeries for my back, or for, an ankle surgery, or for the medication for my leg, whatever it is. Like, you want to make sure it's all there and accounted for just in terms of the valuation side of things. I know for some people that's very difficult. You know, in my experience, I've been doing this a long time. Like, I know how much fee schedule is for a lot of things. I can kind of
Yeah.
like eyeball a lot of medical costs. I would tell someone who's inexperienced trying to figure out how much they want for the medical, go big. You know, just be honest. Like, if you're not comfortable in discussing fee schedule terms or researching that kind of thing using medical billing codes and things like that, just Google. You know, Google how much does back surgery cost me? Or if you got a doctor, talk to your doctor and be like, hey, like if I needed a MRI, how much would that cost? If I needed this medication, how much would that cost? And really
Yeah.
kind of create a spreadsheet or something and math it out a little bit.
Yeah.
Make sure you're getting fair value. Now, with a stipulated award and multiple body parts, you want to be very careful, because if you want to keep your medical open, those body parts and the need for medical needs to be documented within the settlement documents themselves.
So don't take any body part out of that stip. Like,
Oh,
make
yeah.
sure that every, like, if your elbow, your shoulder, you know.
Yeah, like, so you'll see that some people, you know, I've seen it before in cases where clients come to me, they already settled their case, and they say, oh, well, you know, I hurt my back and my knee, but the insurance company gave me a settlement, and now they're only saying they'll only treat my back. And then you
Interesting.
look at the settlement documents, and you'll see that the knee was left out.
Which can be a huge thing.
Yeah, it can be everything. You know, it could, like, maybe you need surgery on your knee now and it's not there. And so we always tell people, you know, hey, are these all the body parts that are involved? Is everything here? Is this all documented? Because you can't really go back and undo a settlement because you messed up and forgot something.
Right.
Usually you'll see when there's an injured worker and they're by themselves, the court will sometimes try to look out for them a little bit more than they would otherwise, and try and, you know, make sure, like, hey, does this settlement really address all the body parts? But
Yeah.
even then, right, they miss things. They're not there to protect the injured worker necessarily. They're the judge. And so they may miss something. They're not always going to look out for you. And so you need to be your own advocate. You need to make sure that it's all there and it's documented.
Would you be in trouble if you, it happens, mistakes happen, people overlook things and they probably didn't think about it. If something was left out, are you shit out of luck?
Kind of.
Damn.
I mean, yes and no. Technically, if, like, your permanent disability wasn't accounted for and your medical needs weren't accounted for a body part, you could allege that there's new and further disability that wasn't there before. But if it was there before, you've settled your case, it's been more than 5 years or something, and you come back and you're like, hey, like, I thought we were settling this, including my knee, and it's only got my back in it, the insurance company can say, no, that's what we intended to do.
Right.
Then you're probably SOL. But if it was a legitimate mistake and the insurance company and you say, like, hey, we both agree the knee should have been in here, but for whatever reason, when we were drafting this thing, it got left out, you can actually set aside the settlement then and have it included. But
Nice.
that would require there being a mutual mistake. And
Right. Someone saying, oops, my bad. Okay.
yeah,
yes.
that would require both the insurance company and you saying, look, this should have been in here, but it wasn't. And, you know, good luck. You can't get them to pay benefits or authorize care. Like, they're not going to come back on a settlement and be like, oh, yeah, you're totally right. We we left out all these things that are going to cost us a lot of money. So
Interesting.
you see that come up a lot, too.
Awesome.
Yeah.
What else do you see in here that you'd like to touch? I see one personally from, I believe his name is Overtime Wayne.
Mm-hmm.
He's had an injury for years, since 07. He's also had a traumatic brain injury, which has gotten him a little bit slower. And of course, it's workers' comp. They're trying to stop treatment and not pay. This is something we've discussed in the past, where the longer a case goes, the more reasons they try to find and stop treatment. They kind of just want to tire you from the system so that you end up giving up. How would you answer to something like that?
I mean, you're battling an insurance company. And to give you a quick story, when I was a defense attorney, we had a catastrophic case. And when you have a catastrophic case, there's a lot more hands-on from the insurance company and specifically the higher-ups, because they take a more financial interest in it, right? When you're talking about millions of dollars on the line, it's not just the adjuster. There's a lot of people with eyes on it. And so
Right.
we had a case and we were discussing it, and, you know, we were talking about the injured worker's morbidity being an issue, and conceivably whether there was any way to kind of drag things out long enough to see if the injured worker died first. Because in California, there are limits on statutory death benefits. And unless you have a very young minor dependent or an incompetent dependent, you know, someone with mental health issues who can't work or something like that, the cap is very, very low, all things considered, for losing a loved one. And so because of that, it's cheaper just pay out some death benefits than it is to administer long-term care or pay millions of dollars in a settlement up front. And so they strategize, that absolutely they try to drag things out and they try to battle and make things such a pain in the ass for you that you just want to walk away. And we see it a lot. And they can do that because they're multi-billion-dollar insurance companies. And, we just represent the little guy. We represent, the gas station attendant, the checkout clerk at the grocery store, the construction workers, the firefighters. We represent these people who really make up the backbone of the community, but individually they don't have the strength or financial capability to sit here and fight for the next 5, 10, 12 years battling it out with these people. And so to some extent, I always tell my clients, like, fight as much as possible. Don't give up. There is a time, though, where you have to start weighing what your interests are and whether your financial needs, your family's needs, your medical needs supersede your desire to have a moral victory over the insurance company.
Right.
And sometimes keeping the case open and battling doesn't always necessarily mean more money. And so you can be in a situation where you're fighting the good fight, but is it in your best interests? It might not be. And so I think that's a personal question.
Right.
And I don't know that there's a catch-all answer for it, but to the extent that there are strategies on the defense side to drag things out, purposely to frustrate you, purposely to wear you down, purposely to put you in a position where you need to settle, that's absolutely valid. And it does happen. It's just a matter of whether or not you can fight back.
Right.
And that's a very personal question. I think everyone looks at individually.
Makes sense. I'm glad that we touched it and even, shared that aspect so someone can think there is not a one answer that fits everybody. Again, every case is different.
Yep.
We've always mentioned that, so.
I got this really great question too here. And this is a question I've had a few times. I think people really enjoy some of the content we put out, and I think I can pride myself on being very knowledgeable with respect to workers' compensation law.
Oh, heck yeah.
That being said, workers' compensation is a state-specific law, and we get questions all the time. Can you take my case? Can you help me?
Right.
And I would love to help everyone, but I am licensed to practice in California. That's where our firm is located. And because of that, I can't practice workers' compensation law in Texas or elsewhere, and I don't know workers' compensation law in every state. And so that being the issue is workers' comp is a state-specific issue, and each state is different. So if you're injured in Alabama, you're going to have different laws than if you're injured in Texas, than if you're injured in Pennsylvania. There are some laws that actually, they're called reciprocity laws, which impact jurisdiction. And there's also situations where people may be living out of state,
right,
but they're injured while working in California or for a California employer, and they can actually collect workers' compensation under California law. It makes it a little bit different when you are working for a non-California company and you're injured in non-California and maybe you're staying in California or something. It's complicated, but there's state-specific jurisdictional issues that do come up in cases. So even though we can't help people who are working and living and injured in, Pennsylvania or whatever, there's still situations where, out-of-state clients come to us for injuries they sustained while working in California for California companies and stuff. And so we can absolutely still help them if they're out of state. Seeking medical treatment and stuff can be a little more complicated because the doctors still have to follow California law when submitting things like requests for authorization and whatnot. So you get doctors who want to throw their hands up because they're like, I don't want to deal with that stuff.
Yeah.
But it's doable. And so we can help with that stuff. But again, if it's not California, generally we can't help. At the same time, there's also, it's called federal workers' comp. So if you're a federal employee, you get workers' comp under a different system other than California or state-specific law. There's also longshoremen, which, obviously you see them working on the ships and stuff like that around in the docks and things like that. They have their own subset of law. Interestingly, in longshoremen cases, though, you can also actually pursue either longshoremen or California workers' comp, depending on what you would like to do. But there's different rules, different compensation for different systems. So I think one thing people should know in response to some of this question is there's a whole bunch of different workers' compensation laws, depending on what your role is, depending on what state, depending on what your employer is. And that's an important distinction, I think.
It's good to know. Yeah. Thank you for sharing that. I think we have time for one more. And do you see anyone that pops up at you. If not,
Yeah, so I think, a question that I got, I think this was one from last week that I had seen, is, related to depositions in particular. People get scared at depositions because they think the insurance company's out to get them. And maybe sometimes they are. It's hard to tell. But, I always tell people when depositions, don't be nervous about it. Just it's your time to tell your story. Don't think of it as this examination like they're going to put a spotlight on you and a camera on you and they're there to make you sweat and they're trying to trap you. Like most of the time they just want to get their information, and as long as you're being honest,
hint hint, as long as you're being honest and you're not lying,
yeah,
it should
don't
be
lie.
smooth.
But you see it a lot where people get really nervous over it, and I'm like, dude, like don't think of this as this like really complex stressful process. Be happy. This is your opportunity to tell them everything about you. Let them know what's up. Tell them about your knee. Tell them about your back. Tell them about your hip. Tell them, how much pain you're in. How much stress you have. Like this is your time to shine and throw it all out there. It's also not your time to make things up or lie under oath, because that'll sink your ship quicker than anything else, right? All we have is our credibility, and depositions are still important. You're testifying under oath just as if you're testifying before a judge or jury in court, and so. It's incredibly important for people to be honest up front, not make up things, don't, exaggerate, don't lie, but also don't hide things. Don't be ashamed to talk about your mental health. Don't be ashamed to talk about your, issues with sexual performance secondary to injuries that happen all the time. Like a lot of people don't want to put their pride aside and they're embarrassed to talk about these things, especially when they're sitting in a room full of strangers and it's being written down and recorded. But like, that's it, man. That's your time to let it all out there. And it's a good opportunity to be upfront, and it really shows who you are and your character and what's going on with you, because most of the time insurance companies, the adjusters don't get to meet you, right? The defense attorney does, and the defense attorney gets an opportunity to assess you as a person, and they make a judgment call internally, I think. And I did this as a defense attorney too. We're all people, and if I sat down in the deposition with an injured worker and throughout the questioning I got the sense that they were a really good person and they needed help, maybe
you'll be more lenient.
Yeah, or I make sure things get addressed, or it changes my recommendations to my client,
Right.
And I guarantee, for me, and I'm sure for other defense attorneys too, when they think that someone's just out there for the money, they think that someone's exaggerating their symptoms, that alters their recommendation going back to their client when it comes time to talk about things like settlement, because they say like, look, this person's clearly making things up. They lied in their deposition. They, said this was hurting, but all these medical records say they weren't. They said they weren't in car accidents before, but they were. Like, no, let's not give them a lot of money to settle the case. Let's lowball them because they don't deserve this. Like, they clearly don't need it. Versus someone where I get the perception they're really in need, they're really injured. I would have probably recommended more that my client pay them as a settlement, because I felt like it was more legitimate. It was adequate.
Yeah.
So I always tell people, now that I've been an applicant's attorney for so long, representing, the injured worker, like
now that you're on the good side.
Yeah, the good side, the right side. Be clear about what's going on with you. Be vocal about it. Be your own advocate as much as you can be, especially in a deposition.
It's good to know.
Yeah.
Awesome. Well, we're going to wrap this up. If you are in need of a workers' comp attorney and you just so happen to be in California, we can always help out. Definitely reach out. We're going to leave the sponsors of our podcast, which is Pacific Workers, the Lawyers for Injured Workers. You can reach out to them. All the links to them will be on the description below as well on the podcast. And check them out. We will come back with another episode of FAQs, frequently asked questions. I wouldn't even be surprised that we end up doing a live form of FAQ on YouTube or any other of our social media outlets. So make sure you stay tuned for that, and we will catch you on the next episode. Thanks, Bilal.
Yep.